Hi, this is Dave at TitleSearch.com. On a typical real estate document, such as a lien or a mortgage or a deed, you'll see the parties on that document identified as either grantor or grantee. So what does that mean? Well, a grantor is simply a property granting away rights in that property, and a grantee is a person or entity receiving rights to a property. So to use the example of a property deed, the grantor is the seller of that property, granting away property rights, and the grantee is receiving property rights. However, at the same time that that property is being sold, if the buyer, the grantee, is also getting a mortgage loan for that property, you'll have a deed, and at the closing you'll sign a mortgage. Well, on the mortgage, the borrower, which is the buyer, is actually the grantor, because they're granting away property rights to the mortgage company. So on the same transaction, two pieces of paper right next to each other, a deed and a mortgage, if Joe Smith is buying the property, he's going to be the grantee on the deed, and then 2 seconds later be the grantor on the mortgage. So on the same transaction, don't look for the same name to have the same identifier. On a lien, the grantor is also the debtor, the person who's having the lien placed against them. So just keep that in mind. A grantor is granting away property rights. Grantee is receiving property rights. They're different on different documents. Loans, deeds, mortgages, liens will have a different identifier depending upon who's getting and who's given the different property rights. If you have more questions about different terms used on title documents, you can reach us at our website at TitleSearch.com.